Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, ascended of Godfrey, the fifth count of Van Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which you call Jesus Christ, I, the Messiah, I, the Anointed One. I come before you on this holy day, being October 8th, 2023, which is the birth year 2973. Back with a marvelous lesson for you all. So I hope you all are ready for a touchdown on understanding the importance of understanding law, participating in law, as well as being able to facilitate it through your own understanding and initiation in the courts of law. And I'm gonna give you some examples. So bear with me. There's so many websites out there that claim to teach on behalf of the people, and I have yet to see one to demonstrate on the level which I presented to you, which apparently have not recognized, and that would not be at your own fault. But nonetheless, it's my obligation and duty to continue to do my diligence to be able to preserve those who do follow the truth. All right, and the truth is undisputed. As I say always, I have not come to change the law, but to fulfill the law. You know, we know the law is concrete, not abstract. It all has to make sense. So I'm gonna make it make sense to you, okay? And I'm gonna show you in real time, i.e. present day, of me acting on behalf of what we call Parens patriae. All right, we know Parens patriae means father of the nation, father of the country, father of the kingdom. You know, a lot of these so-called leaders, world leaders, leaders as far as holistics, whatever classification you choose to fall under, it's nothing without law. Okay, and when I say law, I'm not just going to speak sporadically about it, but I'm going to show you by way of presenting in a manner that's best befitting you, and to show you that your condition will not change until you fall under the protection of the crown. Okay, so with that, let's get started. Where do I want to start here? Parens patriae is Latin for the parent of the nation, parent of one country. In law, it refers to the public policy, power of the state. Hold on for 1 second. Power of the state to intervene against an abusive or negligent parent, legal guardian, or informal caretaker, and to act as the parent or any child, individual, or animal who is in need of protection. For example, some children, incapacitated individuals, and disabled individuals lack parents who are able to or willing to render adequate care, thus requiring state intervention. In the United States litigation, parens patriae can be invoked by the state to create its standing to sue. The state has declared itself to be sued on behalf of you, the people. All right? The state is claimed to be suing on behalf of the people, represented as parens patriae. Okay? And they give you examples. The Hart-Scott-Rodino Antitrust Improvement Act of 1976. Under Title 15, United States Code, Section 15C. And through Section 4C of the Clayton Act, which permits states attorney general to bring parens patriae suits on behalf of those injured by violation of the terms of antitrust Antitrust Act. Okay? Everybody take a couple of seconds and digest that, what I just read. Parens patriae, and it's be taken on behalf of the Attorney General under Title 15 United States Code Section 15C. Okay? So we know, as it said, under Title 15 United States Code Section 15C, under the Anti-Sherman Act, we're protected, and the Attorney General is supposed to bring suits on behalf of the citizens who are protected under the antitrust law. Okay? We know antitrust law deals with the protection against anti-monopolies. All right? Anti-monopolies. Let me give you a court case. Borawick versus Barber. The opinion of the court was delivered by Judge Case. Plaintiff is the mother of a child born out of lawful wedlock. She resides with the child in another state. She filed her complaint in the Superior Court Chancery Division, praying that the court adjudicate the defendant to be the father of the child and direct him to pay the plaintiff suitable sums of money for the care. We're talking about paper currency. Maintenance and education of the child, as well as expenses which were incurred as a result of the pregnancy of the plaintiff and the subsequent birth of the child, together with loss of earnings and other expenses incidental thereto, and that plaintiff as the mother be granted the custody together with the care, education, and maintenance of the child. The Superior Court dismissed the complaint for lack of jurisdiction, and appeal from the order thereon was taken to the appellate division and comes to us on our motion. Okay? We'll go right here. Everyone sees that, right? Before discussing the effect of the express words of the Constitution, we should explore the possibility of an original jurisdiction in the Superior Court acquired from a superseded court to whose power it is the successor. Okay? Whose power it is the successor. The only court through whose power such an inherent jurisdiction could come would be the former Supreme Court, Article 22 of the 1776 Constitution. The common law of England, as well as of so much of the statute law as had been to heretofore practiced in this colony, should remain in force until they shall be altered or by the future laws of the legislature. Article 21 of the same doctrine provides that all the laws of the province contained in edition lately published by Mr. Allison should be and remain in force until altered by the legislature of the colony. The Constitution also by inference, rather than by direct statement, provides for the continuance of the Supreme Court in the legislature 3 months later on October 2nd, 1776. Enacted that the several courts of law and equity of this state should be confirmed and established and continue to be held with the like powers under the present government as they were held at and before the Declaration of Independence lately made by the Honorable and Continental Congress. Okay. It has been held that by the conjunction of the ordinance of Lord Cornbury, enacted in 1704, other ordinances included the ordinance of 1714 passed by Governor Hunter and his council, the 1776 Constitution, the Statute Super of October 2nd, 1776, and the Constitution of 1844. The former Supreme Court became vested with the ordinary common law original jurisdiction of Court of the King's Bench, shared to the same extent by the county circuit courts and the Court of Common Pleas, and that became more exclusively vested with the appellate and extraordinary jurisdiction of the English courts. Did y'all hear that? Did y'all hear that? That's in Borawick versus Barba. We go down to the meat. I think I went over it. Give me a second to find it. I thought I had to save, but I'll find it. Give me a second. Where is this at? It's coming up. I can't believe I can't find this. Remember, we're talking about Parens patriae, father of the nation. Got this light right in my eyes, so it's kind of affecting me. I'm trying not to miss it. I'm gonna go through it. I know it's here. Here we go. There we go. Judge Herher dissenting, there could be no doubt that the former Court of Chancery had jurisdiction of the care of custody of the illegitimates, and that the jurisdiction now rests in the Superior Court under the Constitution of 1947. Okay? This is Barba versus Barba. Barba versus Barba. This has been a function of the Chancery from the earliest times. The general jurisdiction of Chancery over the persons in the state of infants for the protection of both is supposed to have originated in the prerogatives of the Crown, arising from its general duty at Parens patriae to protect persons who have no other rightful protector. So you have no protection outside of the Crown, because if you're not under the Crown's authority, you're under theirs, and therefore under the protection of the Parens patriae of the Attorney General. Okay? But partaking, says Story, as the prerogative does, more of the nature of a judicial administration of rights and duties in foro consentiate than of a strict executive authority. It was very naturally exercised by the Court of Chancery as a branch of its own original jurisdiction. Accordingly, he adds, the doctrine now commonly maintained is that general superintendence and protective jurisdiction of the Courts of Chancery over the persons and property of infants is a delegation of rights and duties of the Crown. That it belonged to the courts and was exercised by it from its first establishment, and that this general jurisdiction was not even suspended by the statute of Henry VIII erecting the courts of wars and liberties. The jurisdiction possessed by the English Court of Chancery from this supposed delegation of authority of the Crown at Parens patriae is more frequently exercised in this country by the Court of the States than by the courts of the United States. You say, hear that? Not the courts of the United States, by the courts of the states, but the courts of the states have abandoned that. They have abandoned that authority, which puts you under the protection of the Crown, being Parens patriae. And now subject you, and made you subject to the laws of what we call the Parens patriae, which is the Attorney General. I'm going to prove it. Let's go here. Okay. This is Billen versus Harris, 487, as supplement 1278, District Court of New Jersey, 1980 case. Everybody sees this. Patricia Harris, Secretary of HEW, United States District Court of New Jersey. Okay, Alice Billings, plaintiff, and Patricia Harris, Secretary of HEW. It says here, the state of New Jersey, whose boundaries coincide with those of the district, is one of the original 13 states of the Union, and is the common law state. The structure of its law may be looked to for the general background about prerogative writs in general and the writ of circulator in particular. The New Jersey's first constitution, adopted July 2nd, 1776 terminated its status as an English colony and began its sovereign existence as a state. Article 22 of the Constitution continued the common law of England in force. That Constitution was replaced by the Constitution of 1844, modeled largely instructive of the content on the Constitution of the United States. Everybody hear that? For Article 10, Paragraph 1, it too continued in force the common law, as well as the existing course of law and equity. So also the current Constitution of 1947, for Article 11, Section 1, Paragraph 3, continue in force of all existing laws. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the power of the King's bench. Okay, with the legislature with power to cut down or to assign to other courts. This principle was especially shown in the fields of prerogative, of which circulator was the one most frequently sought. The complexities and technicalities involved in prerogative writs, including circulator, induced the draftsman of 1947's Constitution to erase the procedural necessities while preserving the judicial authority and the remedy. This was achieved by a single sentence. Prerogative writs are superseded in lieu thereof revealed. Hearing and relief shall be afforded in the Superior Court on terms and in the manner provided by rules of the Supreme Court as right and except in criminal causes which were revealed to be discretionary. All right, 1947 Constitution. Now, once again, I repeat, it says it was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's bench, which legislature was powerless to cut down or to assign to other courts. Let me go a little bit further before this. Right here. Since the federal courts are not courts of general jurisdiction, possessing all the power of the King's bench. You hear that? Since the federal courts are not courts of general jurisdiction, possessing all the powers of the King's bench, the accumulation of precedents in the general field is somewhat nebulous, especially since the law in each of the circuits is controlled by decisions of the courts of appeals, and in particular circuits until such time as decisions of the Supreme Court of the United States resolve difference between the circuit courts. So we know district courts are courts of federal question, as well as courts dealing with diversity issues. And we know those matters are heard in the district courts, which if the decision you don't like, you can put it in one of the circuit courts, okay? And they're telling in this court, in regards to the lack of jurisdiction that the district court have, they're telling you that the state of New Jersey, within this cell, was based off the common law of England, which the Supreme Court could not, which the legislature could not sever. So that means the Supreme Court of New Jersey had more power than what we call the Supreme Court of the United States. I repeat, the Supreme Court of New Jersey had more power than the Supreme Court of the United States. And we know the Supreme Court of the United States was created under the Judiciary Act of 1789, okay? Of 1789. That brings me there. The Judiciary Act of 1789 was the United States federal statute enacted September 24, 1789, during the first session of the first United States Congress. It established federal judiciary of the United States. Article 3, Section 1 of the Constitution prescribes that the judicial power of the United States shall be vested in the Supreme Court. All right, and such inferior court as Congress saw fit to establish. It made no provisions for the composition or procedures of any of the court, leaving this to the Congress to decide. So we know under the Judiciary Act, the United States Supreme Court got their authority. But we know before that creation of that Supreme Court, there was the Supreme Court of New Jersey. And the Supreme Court of New Jersey was invested with the power of the King's bench that the legislature was powerless to sever. Okay, and we know that under the under the power of the crown, we were protected as Parens patriae, which the crown represented. But under the authority of the United States and the states themselves, when they broke away from the authority of the crown, they became Parens patriae under the authority of the acting officer, i.e., either your president or the attorney general or your governor. Okay, we must understand that. That brings me to War versus Keenan. This was a case tried by Chief Judge Vanderbilt. As you can see, opinion of the court delivered by Vanderbilt Chief Judge, Justice Vanderbilt. Before we visit the case, let's see Chief Judge Vanderbilt, because he was the Chief Justice of the Supreme Court under the 1947 Constitution. And we know the 1947 Constitution still under the common law, i.e., the common law of England. So let's go to the 1947 Constitution. New Jersey's Constitution. The Constitution of the State of New Jersey is a basic governing document of the state of New Jersey, in addition to the three British Royal Charters issued for East Jersey, West Jersey, and United New Jersey while they were still colonies. The state had been governed by three constitutions, 1776, 1844, and 1947, which we discussed in Borawick versus Barba. Okay? The first was adopted July 2nd, 1776, shortly before New Jersey ratified the United States Declaration of Independence, and the second came in 1844. The current document was adopted in 1947 and has been amended several times. Okay, it has been amended several times. The original Constitution of New Jersey was called the Sixteenth Agreement. When that Constitution was surrendered back to the Crown, then they came up with what they called New Jersey Constitution, or what we call 1776. Then they had the Constitution of 1844, and then the one of 1947. Okay, so follow the trail. As we see in Village versus Harris, it said the Supreme Court of New Jersey was invested with the power of the King's bench, and that the legislature was powerless to sever. So the Supreme Court of New Jersey, as we read it here on Wikipedia, states that it is the highest court in the United States of New Jersey, and it's in its current form. Supreme Court of New Jersey is the final judicial authority on all cases in the state court system, including cases challenging the validity of state laws under the state's constitution. It has the sole authority to prescribe, amend court rules, regulate the practice of law, and it is arbiter and overseer of the decennial legislative redistricting. One of his former members, William J. Brennan Jr., became an Associate Justice of the Supreme Court of the United States. Okay, this brings me into what we call Chief Judge of Vanderbilt. All right, let's go here. Arthur T. Vanderbilt was an American judicial reformer. He served as Chief Justice of New Jersey Supreme Court from 1947 to 1957. The first Chief Justice under the revamped New Jersey court system established by the Constitution of 1947, in which the Supreme Court replaced the Court of Errors and Appeals as the highest court. He also was an attorney, legal educator, and proponent of the courts of modernization. So we see, and he was appointed by Alfred E. Driscoll, who was the governor at that particular time. All right. So we see Arthur T. Vanderbilt was the Chief Justice of the Supreme Court. And we see that the Supreme Court was vested with the power of the King's Bench, as we see in Billings versus Harris. Let's just go back to that just to validate it before we move forward. New Jersey Constitution, adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. Article 22 of that Constitution continued the common law of England in force. So, I mean, England laws were still in force. That Constitution was replaced by the Constitution of 1844, modeled largely in structure of the content of the Constitution of the United States, i.e. 1789, because you can't get to 1844 until you get to 1789, okay? Article 10, paragraph 1, it too continued the force of the common law. So the common law was here before the Constitution of 1776, at the time of the Constitution of 1786, as well as the United States Constitution of 1789, as well as the Constitution of 1844. The common law was here, as well as the existing courts of laws and equity. So also the current Constitution of 1947, by Article 11, Section 1, paragraph 3, continued in force of all existing laws. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the power of the King's Bench, which the legislature was powerless to cut down. So no matter what law they pass in the present day or in the future, they're null and void in regard to the authority of the common law in which these courts originated their authority from under the Constitution of 1776, Article 22. All right? Let's go back to the case law. What was it? War versus Keenan. It says, thus it is habitually used as a remedy. We're talking about writs, right? We're talking about writs of the common law. Before we go there, we're talking about prerogative writs of the crown as a result of his what we call prerogative power. His prerogative power is influenced by his jure regalia, all right, relating to what we call his radical titles, which is all the overseas possessions that belong to the crown. All right. So I represent the crown as corporation. So therefore, I act as parens patriae on behalf of you. How I know? Let's prove it. Because we know parens patriae can either be represented by the Attorney General or it can be represented by the crown. And as we see in Borawick versus Barba, the Attorney General represented the mother on behalf of some welfare issue that a majority of the mothers are subject to now in regards to the father. But we know that that's the result of the context that we created. But in order for us to get out of this, we must fall under the protection of the crown, because we know under that case law, the crown was parens patriae for all the subjects that belong to the crown. Okay? We're going to prove it in a second. This is the case filed by the king on behalf of those subjects of the crown, on behalf of the English Third Temple Church of England. All right, a complaint on misconduct and complaint of misconduct and the complaint of disability of the judges as regards to the violation of Article 6 of the Constitution, which is the supreme law of the land, going all the way back to the Articles of Confederation. Okay, they're unlawful judges. Why? Because as parens patriae, king at parens patriae, the only person who could speak on behalf of the descendants or the heirs of the crown must be the king. All right. So this is what you're reading today on behalf of the king, on behalf of Europe. And what this complaint is in regards to the judges who are sitting in the district court. And we know the district court were not courts of general jurisdiction because the power of the Supreme Court was invested in the Supreme Court of New Jersey, which now surrendered that power back to Superior Courts, of New Jersey, which is a violation of law. Because we know that Superior Court of New Jersey, under the Constitution of 1776, was supposed to be under the laws of the Crown. We know the Crown is represented by what we call the King's Bench, which I represent, the King's Bench. Okay? So it says, complaint and misconduct and complaint of disability for failure to issue summons and complaint. And the judges were Judge Tiano, Judge Gianni, Judge Robert Kirch, Judge Georgetta Kastner, Judge J. Brendan Day, Judge Zayed N. Korshad, Judge Wooks Sahad L. Singh, Judge Louis H. Goodman, and Judge Michael A. Hammer. And this was the opening statement and the brief statement on the facts. It stated on September 28, 2022, an order, case docketed as Jefferson versus Bank of America, 3:22 CV 04676, Georgette Kastner and Tanyana J. Bojanavani, which were the judge residing on the matter, was given by Honorable Georgette Kastner, granting an application to proceed in form appropriate, which was hinged upon the first act, the Currency Act of 1751, as well as the Currency Act of 1764 and the Paper Currency Act of America of 1772 and 1733. Article 1, Section 10, Contract Clause. Article 1, Section 10, Contract Clause clearly states that the only thing that can be used for payment of debt is gold and silver. So the courts are, these 4 complaints or 5 complaints that I got sitting for the district court, they have now moved as a result of the court's further ruled on the informal appropriates, which would allow me to proceed without paying the fee, because anything other than gold and silver is unconstitutional, which the judge allowed me to proceed, as we just read in the paragraph that I just read to you, based off the case of Jefferson versus Bank of America. Now, this case was dismissed because without prejudice, as a result of it was a notice removal, and the only person that can remove a case to district court is the defendant. So the case was dismissed and it was allowed to be refiled, which you will see now. So these are the cases that were filed in the district court, which have now moved as a result of the formal appropriates to allow me to move forward without paying the fee, because under the stipulated constitutional act, as well as the Act of the United States, Article 1, Section 10, anything other than gold and silver is a violation of law. As you can see, Jefferson versus United States federal government, Department of Treasury, and the Federal Reserve Bank. I'm suing them on behalf of you because anything other than gold and silver is a violation of law. You see Jefferson versus Bank of America, which is the case that was dismissed without prejudice, and it was refiled based off federal question. Jefferson versus the state, in regards to the use declaring us as legal entities versus us being as natural persons, because you cannot be a natural person because you lack a nationality. This was the case brought on behalf of your king to the state, as well as against Judge Clifford, who's an attorney and a judge that sits on the bench of the Superior Court of New Jersey. Okay. Another case in regards to your king on behalf of Parens patriae on the status that was declared on us by way of the birth certificate that was created through the Department of Biostatistics on behalf of the state, as well as the United States Department of Biostatistics, as well as another case between Jefferson and the state of New Jersey, as well as another case between Jefferson and L.B. Holmes, which is a case in regards to our temple, which we're going to have once this case is dealt with. And the complaint based off judicial misconduct and judicial disability is based off the violation of the Constitution of 1789. 1 second. I'm doing the class. Based off the Constitution of 1789. So all these complaints that were not allowed to proceed based off the fee waiver and formal appropriates application as a result of the court not deciding if they were going to allow me to proceed as a result of my reasons for claiming to be exempt from that process, which was validated by our previous order that she granted me based off my argument. All right. And my argument to see here is based off the violation of the Constitution, as well as the Article 6 of the Constitution pertaining to the Article of Confederation, which is the supreme law of the land. Okay. That's the one case you see here. Also, there was another case that was filed against a state judge. His name was Judge Buka. I'm going to show that to you right now. Recently filed for the same reason. They are being unlawful judges. Complaint, letter brief. It's just a brief. Judge Buka has violated judicial conduct by accepting bribes, gifts, or other personal favors relating to judicial office contrary to Article 6 of the United States Constitution and the state's Constitution of New Jersey, which the supreme law of the land, by conducting corporate proceedings prejudicial to the effective and expeditious administration of the business of a constitutional court, such as falsifying facts or violating rules or procedures or evidence. Judge has violated his oath and affidavit pursuant to Section 41:2A-6 of the Jersey Revised Statute. Apparently, Judge Buka is unable to determine who the plaintiff or defendant is in the matter, which is likely to be a disability as a result of such conduct. See order, which I'll show you in a second. Chief Justice of the Associate Justice of the Supreme Court. This is the oath under Section 41:2A-6, which states that the Chief Justice, the Associate Justice of Supreme Court, the Justice of Superior Court, the Justice of the Tax Courts, the Judges of the Municipal Courts, the Surrogate, Deputy Surrogate, and Special Deputy Surrogate, still before entering upon the execution of their respective office, take and prescribe the following oath. I do solemnly swear that I will support the Constitution of the state and the Constitution of the United States, and will perform the duties of my office faithfully, impartially, justly to the best of my ability, so help me God. So they're in violation because they violated the Constitution of the state and in violation of the state Constitution of the United States. Why? Because they're going contrary to the common law of England. As we can see, was read in Villain versus Harris. We read it in Villain versus Harris. All right, let's continue. I'll show you the power of your king. The judicial conduct of Judge Buka was a violation of the law as a result of he being disabled, as a result of him not being able to determine who the plaintiff is and the defendant is, because I moved for a summary judgment based off our authority, okay? Based off our authority. And when this case hit the desk of that judge, Benjamin S. Buka, it must have threw him for a wrench, because as you can see here, it clearly says this matter has been brought before the court on the motion of the plaintiff. Everyone sees that, right? It says on the plaintiff, and it says it has been denied. What has been denied? Let's read why it was denied. The judge stated that the defendant fails to assert facts which can grant a relief. Once again, the judge stated that the defendant fails to assert facts which can grant relief. First of all, I am not the defendant. I am the plaintiff who filed a motion for summary judgment. He never said that I didn't state facts to support my summary judgment, because I got a whole docket of facts supporting why justification should be granted on behalf of the authority, not just on me acting as the corporation sole on behalf of the Crown, but as on behalf of the complaint which was initiated against the defendant in the matter. Okay, but you can see as a result of the decision made by the judge, you can show you that he's shaking in his boots, because he rather denied this motion of summary judgment as a result of the power and authority that was written in the complaint on behalf of me, acting on behalf of the Crown. So the only thing he could do, what does want to be sitting in that office, feeling the heat that I'm bringing in regards to our claim to return land that don't belong to them. He didn't deny me. He didn't deny me anything, because he didn't dismiss my case based off any lack of facts brought before him. He dismissed on behalf of the defendant, and the defendant never even raised a motion before the court, which shows you that this judge is disabled and this is a violation of his judicial conduct, because he did not follow the supreme law of the land, i.e. the Constitution of the state in which my case was based off. All right? So I'm not worried about what they're trying to do or what they're doing as a result of they have waived their authority as representatives of the Constitution and their office that they uphold according to their oath of office. I'm aware of that already. So the only thing we can do is stay the course, but also file claims against them by way of what we call judicial misconduct, which is the disability to their office by way of their oaths to perform their office under what they call good behavior. All right, let's move forward. So as a result of that, this is what I found. I found a complaint, and as you can see, I read both complaints to you, and both complaints fall under Judicial Conduct and Disability Act. What you see here, Judicial Conduct and Disability. All right, that's for the district court judges. This is for your state judges. Filing a judicial ethnic complaint. This is governed under Court Rule 2:15-19, which we'll review in a second. Let's review it. Okay. Constitutional challenge to the proceedings shall be raised in response to a notice received under Rule 215.9, 2:1510, 2:1511, and 2:1512. They should be preserved pending the Supreme Court review of the matter. On the merits, interlocutory relief may be had only to prevent irreparable injury. Motion papers should conform to Rule 2:8-1. If leave to appeal is granted, the record below may, in the discretion of the court, be supplemented by the filing of brief and oral argument. So this review, in lieu of judicial misconduct and disability, is reviewed by the Supreme Court under the arguments brought forth under Billings versus Harris. All right? Under Billings versus Harris. This is why they're reviewing, because the Supreme Court and the authority of the Supreme Court has the power to hear all matters on behalf of the King's bench. And no act of any colorable legislation can violate that or hinder that right. So all the judges who sit in their positions are violating the law, and they're going to be in trouble as a result of the review that's going to be done based off the supreme law of the land under Article 6 of the Constitution, as you can see in both complaints. Article 6 of the Constitution shows you that every judge here in this present day are in violation of the law. Let's see here. It's going back to Chief Judge Vanderbilt, Chief Justice of the Supreme Court, under the 1947 Constitution. And we know under that Constitution, the 1844 Constitution, the 1776 Constitution, as well as under the charges given by the Crown to the properties under the concession agreement, all were subject to what we call the common law of England. All right? And Vanderbilt clearly states that, thus it is habitually used the prerogative writs, which you just seen, what you've seen presented, not just with the complaints filed with the district court, but as well as the complaints filed against the judicial misconduct and disability, were in the forms of what we call prerogative writs made on behalf of you by me as Parens patriae. Who else is doing that on behalf of you, the subjects, the citizens, the heirs? No one has. It says, thus, it is habitually used as a remedy against unlawful taxation, which was subject to, either for state, county, townships, or city purposes, and while the remedy has been denied in other states as dangerous or prejudicial to the public welfare, no such evil has been experienced from the use of the remedy, while it has been found eminently solitary and efficacious, if I'm pronouncing that wrong, efficacious as a protection to private rights against oppressive and illegal taxation. It is used to test the legality of an election, to test the validity of a bylaw of a municipal corporation, to test the validity of the classing and assessing of militias under the Militias Act of 1794, i.e. the Constitution of the United States, to reveal the return list of delinquents and executions issued for the collection of fines imposed for neglect of militias duties, the laying out of roads under an act incorporating a turnpike company, appointments and proceedings of commissioners, appointments to value lands taken by corporations for their use, and to appraise damages by special statutory authority. The special significance of the broad scope of circular 12 in New Jersey in protecting aggrieved citizens from almost every form of improper official action is epitomized by Hartworth in speaking of the prerogative of rich gentlemen. The judicial control could be applied at a suit of the private citizen. The private citizen could set in motion the different forms of procedures open to the crown. And in addition, he could bring a civil action. This power to bring a civil action was an effective control, a safeguard of the liberty of the subject, and one of the best of all securities for the maintenance of the supremacy of the law. You tell me one individual of any society claim to be doing this on behalf of the rights of the citizen, whatever type of citizen you claim to be a part of. The citizen that I'm doing this on behalf of is the citizens of the English Third Temple Church of England, the English subjects, because the law protects English subjects as heirs, as well as their property and as well as their property rights. Okay, we must understand that. Let's see. This is an Imre Van Winkle. Imre Van Winkle. An examination of law in the history of our county courts leads us to the contrary conclusion. By the 1947 Constitution and legislated thereunder, the jurisdiction of courts of common pleas was preserved and made to form a part of the jurisdiction of the county court. The 1947 Constitution, Article 6, Section 1, Paragraph 1, Article 6, Section 4, Paragraph 1, Article 11, Section 4, Paragraph 2, Paragraph 4, Article 6, Section 1, Paragraph 2, Public Law 1948, C.365, the county court accordingly has been invested with the jurisdiction of the former common pleas courts, as well as the former orphan courts, courts of Oryers and Terminers, courts of quarter sessions, and courts of special sessions. The common pleas court the common pleas courts, the origin of which is traced to the orders of the Lord Cornbury in 1704, were preserved inferiorly by the 1776 Constitution of Article 12, and was retained by the 1844 Constitution, since at that time of the adoption of that Constitution, it was one of the inferior courts as now exists. 1844 Constitution, Article 6, Section 1, Paragraph 1, since the county court is presently vested with the jurisdiction of the former common pleas court, it becomes necessary in pursuing the problem to ascertain the nature and extent of the common law jurisdiction of the common pleas courts, and whether such jurisdiction, including the right to issue writs of habeas corpus, it has been determined by our courts that the common pleas court was a constitutional court of record having jurisdiction over common law actions inter partes and proceedings thereunto according to the course of the common law. All right, of the courts of the common law. The origin of this common law jurisdiction over the writs of habeas corpus, which means to produce the body, is lost in antiquity. It was, we have seen from history of the writ, undoubtedly exercised by the Magna Carta and extends in all cases of illegal imprisonment. Whether claimed under public or private authority, it was exercised by the Court of Chancery, King's Bench, Common Pleas, and Exchequer. The inquiry then to be pursued is whether the common law power of jurisdiction of the English Court of Common Pleas to issue writs of habeas corpus had ever become part of the general common law power and jurisdiction which vested in our former courts of common pleas. Such inquiry leads to a negative determination. Keesby Courts and Lawyers of New Jersey, which I got those volumes, the books that he created, contribute to the following statement on the subject. It was the Supreme Court that was expressly given the jurisdiction of the courts of common pleas of England. Did y'all hear that? Hold that thought. Sorry about that. So I just say it said it was the Supreme Court that was expressly given the jurisdiction of the Court of Common Pleas of England. The Court of Common Pleas of New Jersey had that jurisdiction only insofar as it was constituted a common law court of civil jurisdiction between parties and parties. It was expressly deprived of the right to try titles to land, which was originally the special function of the English Courts of Common Pleas. The name of the common pleas was first given to the County Court of Civil Jurisdiction in New Jersey in the first ordinance of Lord Cornbury in 1703. And the name was not taken directly from the English court, but from the court already existing in New York. A history of the origin and jurisdiction of the common pleas courts in the state is given in one of our early cases, State Dufort Prose versus Duque. See 31 N.J.L.302. Super citation 1865, wherein it was related that the common pleas court was provincial court established by the ordinance of Lord Cornbury in 1704, which ordained and declared that the several and respectable courts of the pleas hereby established shall have the power and jurisdiction to hear, try, and finally determine all actions of cases of actions or cause of action in all matters and things triable at common law, of what nature, kind soever. And it was further provided that there should be held and kept at the cities or towns of Perth Amboy, which I now sit, in Burlington, alternatively a Supreme Court of Judicature, which Supreme Court is hereby followed in power to have cognizance of pleas, civils, criminals, and mixed as fully and ample to all intent and purposes whatsoever at the court of the King's Bench, common pleas, and exchequer within Her Majesty's Kingdom of England. At page 305 of the aforesaid case, it is said, the ordinary common law original jurisdiction of the Supreme Court was shared by the respective county circuit courts, and to a definite extent by the courts of common pleas. But the appellate and extraordinary jurisdiction for which the Supreme Court, as successor of the King's Bench, had been originally vested, remains centered still exclusively in that tribunal. Okay? It goes right in line with what Billings versus Harris said. It cannot be severed. It will be observed that the jurisdiction of the given to the Supreme Court was explicit and more extensive than was given to the common pleas court, and excludes the appellate and extraordinary jurisdiction of the several English courts. Habeas corpus is an extraordinary writ and has been considered to be a high prerogative writ issued not as a matter of right, but as a discretion of issuing authority. And Ray Thomas. All right. So we're going to leave that. So we can see that the prerogative writ was the prerogative of the crown to issue on behalf of the subjects in regards to the authority under Parens patriae, which fell under the crown. Okay, so there is no one who's going to speak on your behalf as a representation of the people, as part of the people, other than the crown. Okay, we must understand that. Let's see what Johnson versus McIntyre say. Sorry. Bear with me. My screen go to. Bear with me, y'all. I can't believe my screen just went blank. Okay, here we go. Sorry about that. Bear with me. Okay, we did that. Okay, I want to go here. We know versus Billings versus Harris, right? And go back here. And we read about the Supreme Court of New Jersey and that the district courts have no authority because they're really not general courts of jurisdiction. Since the federal courts are not courts of general jurisdiction possessing all the power of the king's bench. So anything that has to do with the United States has no authority whatsoever. This is the reason why they're being sued for judicial misconduct as a result of their disability. You're not supposed to be sitting in office without taking an oath. All right? You are obligated. That's hand in hand. It says, since the federal courts are not courts of general jurisdiction possessing all the power of the king's bench, the accumulation of precedents and the general field is somewhat nebulous, especially since the law in each of the circuits is controlled by the decision of the courts of appeal, i.e. the Third Circuit Court of Appeals, which I'm appealing to in regards to the judicial complaint for judicial disability, which will pursue in particular circuits until such time as a decision of the Supreme Court of the United States resolves the difference between the circuit court, the United States Circuit Court cannot resolve it because the United States Circuit Court, as well as the United States Supreme Court, is unconstitutional. It is unconstitutional. The state of New Jersey, whose boundaries coincide with those of the districts, you hear that? The state of New Jersey, whose boundaries coincide with those of the districts, is one of the original 13 states of the Union. It is a common law state. So it means that if the state of New Jersey is one of the original states of the Union, then that means it's subject to the Articles of Confederation pursuant to Article 6 of the United States Constitution. All right? The structure of its laws may be looked to for general background about prerogative writs in general and the writ of circulator in particular. Okay? The New Jersey's first constitution, adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. Article 22 of the Constitution contains the common law of England in force, and the Constitution was replaced by the Constitution of 1844, modeled largely in structure in content on the Constitution of the United States. So all of it is synonymous, all right? Article 10, paragraph 1, it too continued the force of the common law, as well as the existing courts of law and equity. So also the current Constitution of 1947 by Article 11, Section 1, paragraph 3, continued in force of all existing laws. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the power of the King's Bench, which the legislature was powerless to cut down or to assign to other courts. So being that it was assigned to other courts, a writ of circulator had to be presented. Once again, a writ of circulator had to be presented. Why? According to Ward versus Keenan, based off what Chief Vanderbilt said. The special significance of a broad scope of the writ of circulator in New Jersey in protecting an aggrieved citizen from almost every form of improper official action is epitomized by Hartwich in speaking of the prerogative writs in generally. The judicial control could be applied at the suit of the private citizen. The private citizen could set in motion the different forms of procedures upon open to the Crown. And in addition, he could bring a civil action. The power to bring a civil action was the effective control, a safeguard of liberty of the subject, and one of the best of all securities for the maintenance of supremacy of the law. Okay? Tell me who out there is doing this on behalf of the people, because I'm showing you I did it. I've done it. Here's my proof. Here's my proof right here. This is all October 9th, 2022. So this is current year, last year and this year, still pending. 1 case, 2 cases, 3 cases, 4 cases, 5 cases. All right, 6 cases. There are still active cases presented on your behalf, on behalf of judicial misconduct that was done by the judges. All these cases that are on behalf of you are sitting on the docket waiting for the cases to be allowed in lieu of the fee waiver fee, which was already allowed in a previous complaint filed, which was dismissed without prejudice, and we filed again. But they're still waiting to be ruled on, because they know once they rule on them, the United States is in trouble. They're in trouble. How you know they're in trouble? Look at this. I'm not playing around. Clerk of the Third Circuit Court. They're all going, each judge. They all got their docket number. Each one got a docket number. 1, 2, we count them. 1, 2, 3, 4, 5, 6, 7. 7 complaints on judges. Each one got a separate docket number, okay, for violating Article 6, Section 1. For violating the common law. Tell me who is doing that. This is dated September 26, 2023. I don't think you can see that. This is for real, y'all, on your behalf. I'm doing this. Who else is doing that? let's take it to the record in my closing. New Jersey Constitutional Convention, Volume 4, page 101. State of New Jersey Constitutional Convention of 1947, Committee on Judiciary, Tuesday, July 1st, 1947, morning session. So I know what I'm talking about. I know what I'm saying has weight. How many people who claim to speak on behalf of the people is presenting arguments like this on your behalf? Not just for myself, but for you. All right? Everybody pull that out. Give you a second before we go through it. When I come to my closing. Okay, so before we reveal this, let's just go back to Parens patriae, which I'm acting on behalf of. We know that we're not able to protect ourselves or our prosperity as a result of antitrust law, because all the monopolies that exist today exist as corporations. Okay, and corporations are deemed as monsters. Why? Because this is the reason why we're in what we call a depression now, the English people. We have no estate as a result of what's going on in these lands, which are a violation of the Clayton Act, right? And the Clayton Act, which was created by the federal government, is not being initiated upon because of the de facto offices of the federal government, which is supposed to be honoring the common law pursuant to the constitutions, not just the state, but the United States Constitution as preserved in Billings versus Harris. Okay? It's preserved. So that means that somebody on behalf of the nation must speak up as the father of the nation, because it's either going to be the king or the attorney general. Okay, it's either going to be the king or the attorney general. It says United States litigation, Parens patriae, can be invoked by the state to create its standing to sue. The state declared itself to be suing on behalf of its people. So as English people, if the attorney general is going to represent you, then he must be an Englishman. Okay? Either he be an Englishman and you be English people, or you be a United States naturalized citizen that has nothing to do with a nation, but based off the color of skin, that being white, that means that those who don't have that color of skin are doomed. All right? You can't participate in all the activities as a citizen. Why? Because everything is anti-you. Everything is anti-you. We don't have the lawful gold. So therefore, we don't be able to buy and trade and sell and commerce with the other nations. Why? Because the other nations are buying and selling and trading with unlawful money. Paper currency, that's the only way they can survive. That's called paper wealth, contrast to real wealth, because real wealth, under the laws governing wealth, i.e. a monetary medium, is only gold and silver. Gold and silver. And I was allowed to proceed in those courts as a result of there is no gold and silver. So therefore, the request for the medium of exchange must be, as we said, waived, which was waived. Now, all the other cases that I brought on behalf of that unconstitutional violation of the antitrust law has got the court stuck. they're stuck now because they know once they let it go, once they let it through, that means that their demise is near. Their demise is near because I am the father of the nation and I come as a representative of the nation, and the nation is the crown. All right. You know it now. They know it. Why? Because we're going to go through their records. Laughter. Everybody see that? They're sitting around laughing, y'all. Laughing. Now there is a moral in what he said there. Well, we're just going to, in lieu of whatever they were saying, is still unconstitutional to the fact of what I'm about to read prior to whatever they were laughing at. It says to understand almost anything, we have got to understand the coming pathway that comes down to us and leads to the situation which we are considering today. And then we are in a position to consider the going pathway that goes out from us. That largely is to be predicted, after all, by the coming pathway by the course it has taken. And that it is profoundly true in this matter of the organization of the courts. Without some idea of its history, we can hardly understand what largely came to be in this country, its fundamental points. Of course, we inherited the English judicial organization when it was at its worst. In the 17th century, when a study of the organization of the courts was first instituted, it was established that there were 90 courts in England that had to be considered. Later, in 1873, when they reorganized the judicial system, those 90 courts became 3, or you might say, in a sense, 4. Multiplication of the courts is a characteristic of beginning everywhere. And even today, we see the administrative organizations moving in that same direction. Every time there's a new administration problem, it is set up by an administrative agency. And our state legislature, every time there is some new type of case that arises, set up a separate court. I have been for 9 years president of the National Probation Association, and I have had a trouble in all those 9 years persuading my friends on the board of trustees not to agree to a lot more courts because when you have this multiplicity of courts, you are eternally bothered with jurisdictional lines and jurisdictional questions. And every jurisdictional question is a waste of judicial power. It is a waste of time, money, and to the litigants. The things that I think need to be avoided more than anything else in all judicial organizations are jurisdictional questions and multiplicity of excessive appeals. Those are the things that waste judicial power and are the things that cost the time and money of litigants. Those are the things also I think that have led in no small degree to the multiplication of administrative agencies and the continual willing away of the jurisdiction of courts, permitting this thing and that in the administration, jurisdiction of the court, and permitting this thing that in the administrative agencies where it is conceived, and I do think it is rightly conceived, that you get speedier results. You will find that this all results in jurisdictional questions, and this multiplied results in excessive appeals. Now as to the coming pathway, we have to ask ourselves how it happened. When Lord Coate instituted his study, he found 90 courts administered, justice in England in the 17th century. Well, there were 13 courts that came down from before the conquest, but the King Court had superseded them in every aspect, everything except local petty controversies. So they had a great system of inferior small cause courts. So they had a great system of inferior small cause courts, from the small beginnings to the well-ordered county courts, of which I speak presently. But in addition to that, the king's power to do justice very largely developed upon the superior court in Westminster for historical reasons and geographical reasons, but their jurisdiction was limited. All probate, all matrimonial controversies, and whole administration of the states at that time was within the jurisdiction of the church. Did you hear that? It was within the jurisdiction of the church until there was a system of ecclesiastical courts. Then again, the king had residual power to do justice in cases of great hardship. And when he found that he had so much of his time taken away with his wars and friends, he turned all these cases over by orders to the chancellor. And there grew up what we now call the Court of Chancery. Yes, y'all, the Courts of Chancery. So you have Coke's time, a great number of local courts which have only a petty jurisdiction air, and the three superior courts of common law, the Court of Chancery and the ecclesiastical courts, and that has struck with us largely. The ordinary organization of common courts in this country coming down from colonial America has pretty well kept up that distinction between the courts of general common law jurisdiction, the courts of equity jurisdiction, and the courts of probate jurisdiction. Matrimonial jurisdiction is passed over to equity because of our forebears in this country wouldn't stand for the ecclesiastical courts, and that passed over into the domain of equity. In addition to that, the King's Bench has the criminal jurisdiction, but it was like trying to dispose of mosquitoes with powerful ordinances to have all sorts of criminal matters brought to the King's Bench. And so criminal jurisdiction got very largely, but not entirely separated. Then too, it was a pretty serious matter. If a man had to come from Northumberland or Westmoreland to London whenever he had an action at law, so the court for general jurisdiction of law was centralized. Nevertheless, the justices went about all over the kingdom to try cases with a jury from a locality. And after the Court of Chancery was centralized, evidence was taken in the locality. The system which you know of the examination of witnesses by commissioners in the locality. That gave us a general picture of separate courts with petty jurisdictions, separate courts with general jurisdictions of law, separate courts of equity jurisdiction, and a separate system of courts with a probate and to some extent matrimonial jurisdiction. Now, the difficulty about the whole system is that it always involved a waste of judicial power and its excessive multiplicity on appeal. In this country, conditions were such after the revolution as to aggravate that situation. Conditions of travel were bad. When Washington was appointed commander-in-chief of the armies of the Continental Congress during the Revolution, he went on horseback from Philadelphia to Cambridge. It took the commander of the Continental Army 8 days. Today, you can go by train in 8 hours, and you can go in much less than that time by air. But it was a very serious situation at the time when our courts were set up to have only central courts. The condition of travel were such that it seemed necessary to have a court at every man's door. And so very generally in this country, the result was to set up a local court of general jurisdiction of law on the model of the King's Bench in every county. This is the reason why I always teach that the courts of the King's Bench was an itinerant court. Itinerant court was a moving court, which means it moved. And this is going to bring me to my closing in regards to the Crown. We know the Crown did exist here in New Jersey. It's called the Provincial Council. As you can see, New Jersey Provincial Council was the upper house, i.e. the House of Lords, of the New Jersey legislature until colonial rule, until it was replaced by New Jersey Legislative Council under the New Jersey Constitution of 1776. And as you can see, the authority and power at that time in Perth Amboy was the Crown. And I represent the Crown. Doing corporations by way of New Jersey by statute 46-3-2, which I'll close on. New Jersey revised statute, i.e. the legislation, what they call put in statutory form, it denotes to certain tenures, i.e. offices, holdings, positions, whatever office you hold, whatever thing you hold, whatever seat you hold, is subject to be removed. Remember, people change. People change, but positions don't. Once again, people change, but the position don't. You took an oath, you're going to hold that same oath that you sat in that chair. When you leave there, that same oath is going to be there. So pursuant to Title 46 of the New Jersey Revised Statute, Chapter 3, Verse 2, it says the tenures of honors, manors, lands, and tenements or hereditaments or of estates of inheritance at the common law held either of the King of England or of any other person or body politic or corporate at any time before July 4th, 1776, and declared by Section 3 of an act entitled an act concerning tenure, 1795, to be turned into holding in free and common sockets from the time of their creation and forever thereafter, shall continue to be held in free common sockets and discharged of all tenures and charges and incidents enumerated in the said sections there. Okay, so there you have it. The full regalia and power of the king. You might not want to recognize it now, but you will in the end. Okay. All right. So I love you all. And once again, I'm not just doing this on my behalf, but I'm doing this for you. And with that, I say peace.